this case. I didn't agree to have your client arraigned from Colombia. So let's start there. Good afternoon, Your Honor. Amy Reiser on behalf of the people.
Good afternoon, Judge Lawrence H. Margolis with and on behalf of Andres. Andres, please unmute yourself and state your name for the court.
Andres.
So, Judge, I think you set this because of the Zoom interruption and the problems we were having identifying a therapist pursuant to the court's grant of our stand-away motion stipulated order in this case. I have heard from Ms. Reiser today that she still is not in possession of the name of the therapist, even though the court has ordered it now 2 weeks ago, I believe. And then Ms. Reiser did also meet with, she said, at least her office did, on August 25th. She met with the complainant in this matter and was advised the therapist is in Venezuela, but yet we still don't have a name. This is Brady material. It's stand-away. Your Honor has ordered the production of it. Well, we believe it is, but
Brady material.
No one knows.
Well, correct. Well, the police report indicates that when she first disclosed this 2 years after the alleged fact, that it was in a therapy session with an individual, and that's what triggered her memory after having it blocked for 2 years. So we believe it is Brady material, but be that as it may, we still don't have a name. So I would ask Ms. Reiser to update the court on her efforts to obtain a name.
Ms. Reiser as to the name.
Sure, and I did email counsel and your judicial staff today that Ms. Wilson, who's the victim advocate on this case, is in the courtroom today. The victim has started a new job, so we aren't able to meet with her in person. She also lives out of state, so the communication has been either by text or email, and I was not able to meet with her by Zoom last Friday. She does not remember the name of the therapist that she saw in 2018 that is mentioned in the police report. So that's the information that I have to report to the court right now, is that she doesn't remember the therapist's name. And I do agree with Mr. Margolis that it would be likely ordered by the court, but she just doesn't remember the name. So I'm not in possession of any Brady material. I'm not in possession of something that I'm not turning over to the court. My colleague who handled the case before me agreed to this without speaking to the victim, without asking who the therapist was or if we could locate the therapist. I don't even know if the therapist is still alive or practicing. So I don't have a therapist's name.
So I provided the court, through your judicial assistant, 2 proposed subpoenas, orders that I would request that the court sign, at least to allow us to subpoena the records, whatever therapy records she's able to provide. I find it very difficult to believe that she doesn't remember a name of a therapist, first off, to the complainant. And I think the complainant's new therapist would probably have mental health records of any previous therapist located in the same city. I will take Ms. Reiser that's what was advised to her, that the complainant doesn't remember her therapist, where she disclosed such an important fact that led to the charges against my client years and years after it allegedly happened. But I don't believe the complainant.
So, I mean, it's not really an accurate recitation of the facts of this case, and I'm happy to go into them if Your Honor would like, but the victim didn't report this right away because she had moved out of state after the defendant assaulted her in March of 2016 in his home, where she lived with him, and she was a related relative by blood or affinity, so it could be charged CSE second. She left the residence in July of 2016 and moved to Rhode Island. She was a teenager, 15 years old. So she didn't know how to report it because it happened in Michigan in his residence.
That's
did
actually a
indicate
misstatement,
when
Judge.
she
I'm not
was-
going to let her besmirch my client and the record with that. The actual report states that in 2018, she hugged somebody, an odd hug that she received, and that triggered the memory of a sexual assault. She stated that in September 18, she told her psychologist about the triggered memory. She says it was blocked for several years. And Ms. Reiser is claiming that she didn't say something because she was living in Michigan and she was too young is not true. She said that her memory was blocked for 2 years.
I don't think that's usually so that.
So
Go ahead.
she did report, Your Honor, reporting this to a psychologist in 2018, and then indicated she was living in Rhode Island and didn't know how to report the assault that occurred in Michigan. So she did report it to authorities in Michigan in 2020.
And how many psychologists could there be in that small town in Rhode Island?
I'm not sure.
Why can't we find who that was, is what I'm saying. It seems to be up to the people.
That we could give her an opportunity to see if she can more with the victim and their family to figure that out.
Understood, but her office stipulated to the production of these records in early July. And now we're in September.
So, and it didn't, to be honest, the stipulation is somewhat wanton. It didn't list how many therapists, it didn't list any names of therapists, it just said therapist records. It doesn't even like pass the smell test on Stanaway, the stipulation to know that this is one, not a fishing expedition, and two, to look at what are the probative records.
Well, I appreciate the court's concern about that, but the prosecutor agreed that I'm entitled to the records from 2017 to the present. So it would be incumbent, we believe it'd be, well, actually, I think it is in the one order that was.
I didn't agree to anything. I just let's be clear here, Mr. Margolis. I haven't been handling this case. In fact, when I spoke with you at the onset of this case, I didn't agree to have your client arraigned from Columbia. So let's start there. You and Mr. Dowd agreed that this arraignment could happen from Columbia, that your client could appear for exam from Columbia. Then Mr. Dowd waived the exam and I think inappropriately dismissed one of the counts. So now we're up in
that would be a
circuit
matter to take up with Mr. Dowd in your office.
And I
If
will,
you
but
want to
you
try to revoke a stipulation of your own office, then I think the proper paperwork should be filed. If your office brings a charge and you seek to prevent my client from being able to answer the charge, where is his due process there?
I'm not
we
seeking
wanted
to
to get it
prevent him
arraigned
from
via
doing
Zoom.
anything.
We
I'm
wanted
putting
you-
you on notice that the charges are inappropriate, so the case may be dismissed and reauthorized. That's what I'm
Perfect.
telling you.
That can get him here to defend the case against these fabricated allegations.
Stop for 2 weeks, so I'm not gonna listen to you guys go back and forth on the record. I'm officially over this argument. 9/21 of 2023 at 1:30. Ms. Reiser, do whatever it is you're going to do. If you're not dismissing the case, please make additional efforts to figure out if there's therapists can be located in Rhode Island. If not, file a motion regarding the Stanaway. I didn't sign the order, so
Which order? You said last time 2 weeks ago, you said you're signing the order.
if I had a therapist's name, I needed another one provided to me.
Thank you, Judge.
Thank you.